Stephen Keim and Samuel Lane were co-counsel in the recent matter of Derek Bromley, where in December 2023 the Australian High Court delivered an agonising 3-2 decision denying Mr Bromley leave to appeal against his conviction. Stephen addresses the majority decision in the Bromley case, followed by Samuel, who reflects upon the minority judgment. Both Stephen and Samuel were valuable members of the organising committee for this event as well.
Sam and I, along with our tireless instructing solicitor Karen Stanley and our co-counsel Greg Barnes and Mr Bromley himself and his friends and supporters, have shared that journey of a lengthy litigation experience. A lot happens to you as human beings in such experiences, and the friendships and relationships you form usually endure for the rest of your mutual lives. I'm sure that will be the case with us. When the journey ends with a very close decision and the case for which you have argued finishes on the losing side of the numbers, I think we are tested as human beings and as advocates. I think all of us involved in that journey are still being tested, and we're doing our best to meet these challenges. Sam and I have simply divided our task into the majority and minority decisions. I'll try to capture the reasons why the majority of 3 High Court justices concluded that Mr Bromley's application for special leave should be refused. And Sam will articulate why the 2 remaining justices would have granted special leave, upheld the appeal, and in their discretion declined to order a retrial. The effect of all of that is that if one of the majority had joined the minority, Mr Bromley's case would have joined the pantheon of famous miscarriages of justice. He might even be with us here today. As it is, his case is simply an unsuccessful application for special leave against a dismissal of his appeal under the South Australian Second and Further Appeals legislation. One caveat I do want to make is that when you read the judgment, all 169 pages of it, in one sense it's only half of the argument we brought, because the application for leave to appeal first came before Justices Keim, Edelman and Stewart on the 16th of September 2022. The court adjourned after argument and after some delay and came back and made an order that the application for special leave be referred to the full bench of the High Court for argument as on an appeal, but limited to the ground whether the fresh psychiatric evidence was compelling and whether it was in the interest of justice on the basis of that evidence that it be considered on the appeal. So the importance of this limitation flows from the fact that there were 2 bodies of fresh evidence on which the original appeal and the application for special leave had been based. One was the psychiatric and psychological evidence, which was considered in the judgment that was delivered late last year. The second body of evidence was fresh evidence from a number of pathologists. So if you want to read, and my notes set out some aspects of the pathology evidence, but if you want to read the full Bromley story, then you'll have to delve into that half of the argument as well. I'll leave it for today on the basis of limitation of time. So now I turn to the majority's decision. The majority's decision was contained in a joint set of reasons by Chief Justice Gageler and Justices Gleeson and Jago. The majority commenced its reasons by noting that refusals of application for special leave were not traditionally accompanied by lengthy reasons, and the justification in the present case involved the circumstance that the basis put forward for special leave was the interests of justice in the particular case, rather than a matter of general importance to the law. And the resulting circumstance The court referred one aspect of the application to be the subject of a full argument of the merits as if it were on appeal. So don't expect every time you get refused special leave 96 pages of refusal. The majority set out aspects of the procedural history of the case. Mr. Bromley was convicted along with John Carpeney on the 14th of March 1985 for the murder on 4 April 1984 of Stephen DeCosa. Mr. Bromley was unsuccessful in an appeal to the Court of Criminal Appeal in South Australia and subsequently on an application for special leave to the High Court. The court noted that Mr. Bromley was still in jail. The application for the application for permission under the second appeals legislation was filed in South Australia in 2016. The Court of Appeal handed down its decision in 2018, and Mr. Bromley's special leave application was filed on the 24th of November 2021. So Sam and I and Karen and Greg, we got on board somewhere between the 2018 judgment and once we'd read the material, which took us a couple of years, the filing of the special leave application in 2021. So you can see that ours was a pretty long journey, but Mr. Bromley's journey is a lot longer than that. The fresh psychiatric evidence came from 3 psychiatrists and 2 psychologists. And I think Professor Ian Coyle may be with us today. He's certainly registered, and his evidence, along with the others, was a fantastic piece of unrewarded evidence on the part of each of those witnesses. The witnesses had provided expert reports and had given oral evidence, including cross-examination, before Justice Stanley on a remittal from the Court of Criminal Appeal, where they were cross-examined. The evidence addressed developments in the field of cognitive deficits or impairments in people suffering from schizophrenia and schizoaffective disorder, and the effects on memory since the 14th of March 1985, when Mr. Bromley was convicted. I won't go through the case law and the contents of Section 353 capital A, which sets out the basis on which a second appeal, permission for a second appeal may be given. But I think that case law is interesting, and you'll see that it's not a gimme in order to get an appeal. You do have to establish quite a few things about the fresh evidence. So going on with the majority's reasons, they referred to the summing up by the trial judge in the trial of Mr. Bromley and Mr. Carpeney. The trial judge said that the witness, Gary Carter, and this will give you some idea of the issues in the case, undoubtedly had a mental illness. Carter was more affected by that illness on the night in question than when he gave evidence, and so the jury got a different impression of him in that regard. The jury was required to approach Carter's evidence with considerable caution, especially as the Crown prosecutor had stated that it was so crucial to the Crown case. The jury was told that they must scrutinise Carter's evidence with special care, but the jury was entitled to act on that evidence if they were convinced of its accuracy. The judge also said that in some important respects, Carter's evidence was mistaken. He was clearly mistaken in believing that all the victim's clothes were removed. He was clearly mistaken in believing that Mr. Bromley, and this was the trial judge's words, laboured the victim with a barbell. The judge said that Carter was supported by independent evidence to a substantial extent, and the jury were instructed that if after scrutinising Carter's evidence and after bearing in mind the earlier warning, if such independent support persuaded the jury to accept some or all of his evidence, they were entitled to do so. Importantly, when considering the view taken by Justices Edelman and Stewart, the direction did not require Carter's evidence to be corroborated for the jury to act upon it. The majority usefully summarised Mr. Bromley's argument as being that the fresh psychiatric and psychological evidence, properly understood, means that each and every part of Carter's evidence is potentially unreliable. While parts of Carter's evidence had been corroborated, his identification of Mr. Bromley as the man who, with Carpeney, attacked the deceased was not corroborated. The fresh psychiatric and psychological evidence in the argument demonstrated that in the circumstances of Carter's illness, this uncorroborated evidence identifying Mr. Bromley as a person who attacked the deceased was unreliable. And also part of our argument, as recorded by the Court of Appeal, fairly I think, the trial judge's direction did not say that no part of Carter's evidence could be accepted unless corroborated, contrary to what was required as demonstrated by the fresh psychiatric and psychological evidence. So that was the case that we put to the High Court, and this is what the majority found. And I will be summarising, perhaps to the point of unfairness, but the judgment is so long and time is so short, that's what we have to do today. I think it's fair to say that the approach of the majority was very similar to the approach taken by the Court of Appeal in South Australia. The Court of Appeal's approach is reflected in the majority's summary of the Crown's arguments before the High Court. It was said that all of the psychiatric and psychological experts accepted that a person with schizoaffective disorder is capable of accurately recalling events, or may be capable of accurately recalling events. The extent to which other evidence confirmed Carter's evidence would be relevant to an assessment of his reliability, and they had not fully assessed the evidence that confirmed parts of Carter's evidence. The Crown went on to argue that the opinions in the reports that Carter was a wholly unreliable witness were unsustainable, such that the evidence was not highly probative and thus not compelling. It was essentially this argument that found favour with the majority. The approach by the Crown and ultimately by the majority places emphasis on the concessions made by the psychiatrists and psychologists who gave evidence, concessions made in cross-examination. Those concessions were, one might think, sensible. They included a concession that a seriously psychotic person could remember some things accurately, and that some non-psychotic people can fall subject to fantasies. They also included concessions that the extent to which a psychotic person's evidence is corroborated is a factor in assessing their reliability. And they were concessions made at a generic level. And I think it's fair to say that the Court of Appeal, the Crown and the majority in the High Court treated those concessions as really undermining any of the opinions that the experts had given, subject to seeing to what extent the corroborating evidence had with regard to Mr. Carter's evidence. Now, the one bit of analysis I wanted to say was with regard to what was an implied criticism, both at Court of Appeal and majority level, of the experts and the lawyers who briefed them for the purpose of obtaining opinions, including in two cases, Crown lawyers, because one of the pathology witnesses and one of the psychiatric and psychological witnesses were actually briefed by the Crown but not called by them. And the criticism was the experts didn't see the whole of the evidence in the case, so they weren't able to make a full assessment of Bromley's, of Mr. Carter's reliability, and therefore the evidence of those witnesses was diminished in value. And what I say about that is the experts were essentially required to give a clinical opinion. For that purpose, it was important to have clinical notes of what Mr. Carter did and said, both before and after the night of the death of the victim. It was not essential to be briefed with every piece of evidence in the case, because that's the court's job. The clinical opinion was that Carter, with the medical condition he was experiencing, was much more likely to be unreliable as a recaller of fact than was understood by medical science at the time of the trial. He had a medical condition, and his evidence was crucial to the Caron case. So why was that evidence not compelling? That's the criticism I raise. It still remained a task for the court on an appeal, once permission had been given, to see whether the effect of the evidence taken with the evidence at trial meant that there had been a miscarriage of justice. But it wasn't up to the psychiatrist to say whether the verdict was unsafe or not. And I think there are two problems for the future that come from that. One is, I think it's going to be very hard to get to first base on these sorts of applications in the wake of this High Court's decision. But I think the other thing is that people are going to expect and brief experts to do the role of the court in future applications, which I think is not a good thing to happen. And this is really summarising to the extreme. What you get in the two sets of judgments is two groups of very clever people doing an intensive analysis of a complex series of facts. What I feel the majority did was to look for fragments in which Mr. Carter got it right and to place much less weight on those things where Mr. Carter got it wrong. And even when you're looking at inconsistent versions of events, which really did suggest pretty strong psychosis, again, and I make this point, if a person gives a narrative with regard to something and they change their story in 1% of the story because the stories doesn't quite add up, you've still got 99% of it which is unchanged. And so the percentages might have been closer to 50-50, but the majority concentrated on the 50% which was unchanged rather than the 50% which had changed. And, that in a sense is a normative judgment with regard to fact finding. And obviously different judges will have different approaches in different cases to the same body of evidence. We see judges differing on factual analyses quite frequently, but that seems to be the difference here. Thank you.
As Stephen mentioned, I'll be addressing the minority judgment. My intention in the short time that we have is to focus on the minority's assessment of the facts and the conclusions that they reached as to their significance. I'll also touch upon a couple of points that we raised in our submissions to the court and how the minority differed from us in respect of those matters. Now, at the outset, I should explain that the minority reasons are divided up into 10 parts. I'll be addressing only a very limited part of that. The first part of the reasons of the minority sets out the legal framework for the application. The second part, the minority sets out the evidence relevant to the application, which they say are the different versions of evidence of the assault in particular given by the witness Carter. This separates the versions of evidence given by Carter at trial and of the other witnesses who attributed certain statements to him and the hearsay accounts of what Carter said, which were not part of the evidence at the original trial. Thirdly, the minority describes the most significant errors and inconsistencies in Carter's various accounts of the assault, and I will spend some time considering these points. Fourthly, there is consideration of the admissions said to have been made by Mr. Bromley's co-accused, John Carpeney. The minority then sets out in detail the Crown case against Mr. Bromley insofar as it concerns the actual assault, which the minority considers to be the crucial event. Sixthly, there was consideration of the fresh expert evidence, which I will touch on briefly, but it does pay for people to read that on their own. The seventh part of the judgment considers the significant areas of agreement between those experts, which is the ultimate conclusion being that there was no way of knowing without independent corroboration whether witness Carter was in fact reliable about anything that he was saying. The eighth and ninth parts of the judgment consider that conclude that the fresh evidence was compelling and that it was in the interest of justice to consider that evidence on an appeal. And the 10th and final part is the conclusion of the minority, which I'll return to later. Now, as I mentioned, my only real focus for today is on the key factual events and the minority's assessment of them. Now, the minority decision itself takes a different approach to the assessment of the evidence that the majority did. And while one might say that's a common sense conclusion to draw, given that they arrived at the opposite answer at the end of the hearing, I'm really speaking about what was a quintessential, or what should be a quintessential approach to looking at the evidence in these types of appeal cases. And I say this bearing in mind the well-established line of authority to the effect that the evidence in second or subsequent appeals must be given the interpretation that is most favourable to the applicant. I consider that this is how the minority viewed the evidence. And in my view, and you might say that my view is tainted with bias, the minority took the correct approach. We've heard Stephen discuss some of the evidence that was critical to the Crown case from Mr. Carter, and we've also heard now how the majority in certain respects relied on parts of Carter's evidence that was corroborated, although that wasn't relevant to the actual assault. That is, there was some independent evidence that corroborated certain things that Carter had said in his evidence, but that evidence and that corroboration was only in respect of matters that occurred before or after the assault. Now, the minority themselves considered the evidence from those 3 points, before, during, and after the assault. But interestingly, Justices Edelman and Stewart considered that the evidence before and after the assault was a distraction from the events of the actual assault. And they said, and I quote, "The accuracies and inaccuracies of Mr. Carter's account of mundane events before and after the assault provide little guide to the accuracy of his account of the critical and emotional event of the assault. As was said by the psychiatrist who was instructed by the Crown to give expert evidence, for a person with Mr. Carter's psychiatric condition, if you were asking something that was simple and concrete and emotionally neutral, you could expect to get a more reliable account." They went on to say that even if Mr. Carter's account of those mundane events before or after the assault were entirely correct, which they certainly were not, and even if his accounts of those mundane events were corroborated in every essential respect, which they were not, the jury could not convict on that evidence. It was Carter's account of the assault that was crucial. Now, I said before that the approach of the minority was interesting, and that's because it is also slightly different to the approach to Carter's evidence that we took before the High Court. We argue that the new psychological evidence was to the effect that unless Carter was corroborated on every aspect of his evidence, that you could not be certain that what he was saying was reliable. It is true that he could be reliable about some things, but in the absence of that independent corroboration, you just simply could not know. The Crown, on the other hand, sought to argue that as Carter had been corroborated on a number of matters not relevant to the actual assault, that he could be taken to be reliable generally. With this in mind, we observed a great number of statements made by Carter before and after the assault that were contradicted by objective, independent evidence. The point of this was to say that while the Crown sought to rely on certain, albeit relatively minor, evidence corroborating Carter's account, there was also various other parts, numerous in fact, of Carter's evidence that were contradicted by the objective evidence. As a consequence of this, the so-called independent corroborating evidence of Carter relied upon by the Crown could not be viewed in a vacuum to allow his otherwise uncorroborated evidence of the actual assault to be treated as reliable. In effect, we submitted that Carter was more unreliable than he was reliable even on the mundane events. In those circumstances, how could you be sure about his reliability of the actual assault itself? We had made submissions regarding inconsistencies in Carter's evidence before, during, and after the assault, and unlike the minority, we did not consider that those before and after the assault to be a distraction, but rather a relevant path in mapping Carter's unreliability. Looking at Carter's evidence of the actual assault, though, the minority very carefully set out critical areas where Carter's evidence was, and I use the minority's words here, either extremely unlikely or inconsistent with established facts. Firstly, they identified that Carter gave evidence that Mr. Bromley was drunk when they arrived at the banks of the River Torrens. Indeed, Carter's evidence was to the effect that he was stumbling and staggering. He was the most drunk out of anyone in the group. However, the evidence of a police officer who had spoken to Mr. Bromley later in that evening, although not at the scene of the crime, was to the effect that Mr. Bromley was not affected by alcohol. Secondly, Carter gave evidence of a dumbbell being used at trial to strike the deceased. The manner in which he described this was that he held a dumbbell over his head and struck it straight down with some force. However, the forensic pathologist at trial described the injuries of the deceased as being totally and absolutely inconsistent with the description that Mr. Carter had given. Perhaps more startling, though, was the trial judge's explanation of this to the jury, where he stated that Carter was merely mistaken in believing that Mr. Bromley laboured the deceased with the barbell. The judge then offered his own alternative to the jury, saying that the applicant picked it up, that the deceased may have been struck with one or more glancing blows, but the fact remains that Dr. Manick's evidence undoubtedly proves that Carter was mistaken as to the use made by Mr. Bromley of the barbell. Thirdly, the minority identified that Mr. Carter gave evidence that the deceased's pants had been cut off with a knife. Yet, there was no knife found at the scene of the crime, nor was there any suggestion that on the night in question Mr. Bromley had a knife on him, nor were there any cuts or other markings on the defendant that would have suggested an assault with a knife. Fourthly, Carter gave evidence that the deceased had been stripped naked of all of his clothes, and that was not the case, as the deceased, when he was found, was only naked from the waist down. Fifthly, Carter had given evidence that Mr. Bromley was kneeling on a landing on the banks of the Torrens and was dunking the deceased's head underwater. However, the minority identified that the evidence of the police diver who had recovered some of the evidence from the River Torrens observed that even 2 metres out from the landing on which Mr. Bromley was said to have been dunking the deceased's head underwater, that the water was only 60 to 90 centimetres deep, so that there must be serious doubt about whether the deceased's head could have been held underwater in the manner described even in the more shallow water that was near the landing. The last point I'd raise, and this is not the last in the judgment, was that Mr. Carter gave evidence to the effect that he had helped the deceased out of the water after the deceased had rolled into the water. However, when asked if he had got wet in the process, he said, "No, I'm not quite sure." And this is despite having to wrap his arms around the deceased under the armpits to help him out of the water. At least that was his account of it on his evidence at the trial. Justices Edelman and Stewart then address what is very clearly the most significant factor for the unreliability of Carter's account of the assault. That is that at the time of the assault, he was suffering from schizoaffective disorder and was acutely psychotic and hypomanic. Carter gave evidence that he had seen the devil and that the devil had spoken to him. Again, this was at the time of the assault. The day after the assault occurred, Carter was admitted to Hillcrest Hospital because of his psychiatric condition. There, he gave various versions of the assault with differing degrees of detail to various people, including the police. I should note that at that time, the police considered that in his state, he could not give useful evidence. Among some of the statements that Carter made to hospital staff and others prior to his evidence at trial were that he was a martial arts expert with black belts, he was going to play football for Port Adelaide, he defended the deceased with nunchuckers, he saved the deceased's life by putting some drugs in his mouth, and that he was a millionaire. While the jury was aware of what he had said with respect to playing football for Port Adelaide, they were not made aware of any of those other statements that I've just mentioned at the original trial. There were other inconsistent statements that Carter made of which the jury was not made aware, which the minority also address. The minority also conducts a careful review of the fresh expert evidence regarding Mr. Carter's psychiatric condition. The fresh psychiatric evidence was the only new evidence that we were permitted to address at the hearing, as Stephen mentioned. This evidence was significant. And while I do not have time to address all of that evidence in detail, I make the following observations. The new psychiatric evidence unanimously was to the effect that since 1984, when the assault occurred, there has been a development of a body of psychiatric knowledge concerning the condition of schizoaffective disorder. And as a consequence of this, we now have a much greater understanding of its effects. As it is now understood, schizoaffective disorder will affect an individual's reliability as to their recall. They are very vulnerable to suggestibility and confabulation. It is impossible, particularly where the particular person is in an acute episode, which Carter was at the time of the assault, to know what is true and what is an invention. A very succinct summary of the condition and the effects of it on Carter was given by the expert Dr. Brereton, who Stephen mentioned earlier, who provided an expert report for the Crown. Although he wasn't called by the Crown, Mr. Bromley's team had to do that. In his report, Dr. Brereton concluded that almost the entirety of Mr. Carter's evidence would need to be corroborated before he would consider his reliability had been sufficiently demonstrated. This was from the Crown's own expert. Other experts who were relied upon and considered by the minority included Professor Coyle, who noted in his cross-examination that while Carter might not be incapable of being accurate, Carter's ability to recall what he saw would have been grossly affected, and that it was not possible to be certain about anything he claimed to have observed. The minority noted that there were significant areas of agreement among all of the expert witnesses. This included as to Carter's low reliability. Professor Coyle and Doctors Brereton and Sugarman all agreed that there was no way of knowing whether anything that Carter had claimed to have seen could have occurred or whether it was a hallucination absent the independent corroboration. The minority then assessed the expert evidence as being, to use their words, plainly compelling. It was highly probative in the context of the key issue in dispute at the trial, namely Carter's reliability and the adequacy of the judge's direction to the jury. The minority then considered whether the independent evidence said to support Carter's testimony required a different conclusion. Was the independent and circumstantial evidence such as to preclude the characterization of an expert evidence as being compelling? Now, a number of the authorities that we've relied upon state that when evidence is compelling, it will almost always be compelling, but there might be circumstances where there is independent evidence. And the example that's often used is a post-conviction confession that's made by an individual. That might be such that new evidence might not be compelling. I won't have time to address that part of the judgment in detail, but again, as with the balance of the points raised, the minority did conclude that the independent and circumstantial evidence did not preclude the conclusion that the expert evidence was compelling. Now, there is, at this point, one point that I did want to address from the minority decision, which conflicts with the submissions that we made to the court. And this concerns the identification of the man said to be Mr. Bromley, who got into the taxi in Hindley Street with Carter, the deceased, and John Carpeney, Mr. Bromley's co-accused. This is where, in terms of the chronology of events, where Mr. Bromley comes to be together, according to witness Carter, with the deceased, John Carpeney, and Carter. Now, the man who got into the taxi, according to the independent evidence of the taxi driver, Mr. George, was described as being very dapper. That man was wearing a white full-brimmed hat, a white suit, black shirt and a white tie, and probably had white shoes on. The taxi driver, in his evidence, said that the man stood out. They were in the middle of Hindley Street, which at 2 a.m. in 1984 was not a particularly savoury part of town. Think about the Valley in the 80s. A person dressed in that way stood out. The taxi driver's evidence on this point was clear. On the night in question, though, Mr. Bromley was wearing almost the exact opposite. He was wearing a dark zip-up jacket, dark jeans and shoes. He had no hat. If the taxi driver's evidence is to be believed, then Mr. Bromley never got in the car and did not travel to the banks of the River Torrens with the deceased Carter and Carpeney. The minority, however, did not consider this to be as significant as we did. They noted other circumstantial evidence that put Mr. Bromley near the scene of the crime, which may have meant that he was there. However, the minority accepted, as we had submitted, that even if Mr. Bromley was there, which we did not accept, there was no reliable evidence of his involvement in the assault, and Carter could not be relied upon for that purpose. I'd like to end my discussion now by quoting the concluding paragraphs of the minority decision. There was no dispute that this court is in the same position as the Court of Criminal Appeal and capable of making any order as ought to have been made by the Court of Criminal Appeal, including orders by the Court of Criminal Appeal granting permission to appeal and disposing of the appeal. Indeed, the jurisdiction of this court is to pronounce the judgment which the Court of Appeal should have pronounced. We would therefore order that special leave to appeal be granted, the appeal be allowed, the order of the Court of Criminal Appeal of the Supreme Court of South Australia be set aside, and in lieu thereof, an order be made that permission to appeal be granted, the appeal to the Court of Criminal Appeal be allowed, and the applicant's conviction be quashed pursuant to Section 343 A4 of the Criminal Law Consolidation Act. In all the circumstances, including, for example, the death of Ms. J. Carter, the loss of the original exhibits, and the time spent by the applicant in prison since 1984, there could be no suggestion of an order for any new trial. None was suggested. In circumstances in which a new trial is not appropriate, there should be an order for an acquittal. Thank you.